Hello and welcome to the Law Lab. Here we dissect and unpack everything legal. My name is Rhysa Iris Ewonia and today I'll be taking you through mortgages. In Ghana, mortgages is governed by the Land Act 2020 Act 1036 and the Mortgages Act 1972 NRCD 96 as amended. In the normal English parlance, a mortgage is a contract between a mortgagor and a mortgagee where the mortgagor's immovable property is used as a charge or security for the repayment of a financial assistance that has been advanced by the mortgagee to the mortgagor, together with any accrued interest. Mortgagors and mortgagees are actually people in this particular instance, and mortgagees are the people who give the financial assistance to the mortgagors. So usually when it comes to institutions like banks, the bank in itself is the mortgagee, and the people who go for loans from the banks are the mortgagors. These people can give their immovable property as collateral to the loan they are taking from the bank. And when that happens, a mortgage has therefore been created. So mortgages have mortgagors and mortgagees, and there are financial assistance or money that is given, and there must also be an immovable property involved. For my definition of a mortgage, you'd realize that one of the key characteristics of mortgages is that it's a contract. A contract means that there must be an offer and acceptance of that offer, and reasonable consideration must be given in relation to that offer. So the contract must be an agreement. So mortgages must necessarily be agreement between persons involved. It must also be reduced into writing. So you cannot have an oral mortgage. It must all be reduced into writing, and there must be two separate people involved. These people could either be persons, natural persons, or juristic persons. It does not matter whether it is an individual or it is a company, but there must be people involved. There must also be an encumbrance on the property. An encumbrance in land is any right or interest that exists in someone else's land other than the owner of the landed property, which restricts or impairs the transfer of the property. When it comes to mortgages, it is the mortgagor who is going for loan or the financial assistance from the mortgagee. And from my definition, I stated that the mortgagor must have an immovable property. When the mortgagor approaches the mortgagee for the creation of this mortgage, an encumbrance must be placed on his or her immovable property. This encumbrance is sort of like a burden. It restricts how the owner of his own immovable property uses that property. In fact, if the mortgagor has intentions of selling a mortgage property, he must necessarily inform the mortgagee and the third party who is seeking to buy that property of the existence of the mortgage, because an encumbrance has been placed on it. When an encumbrance has been placed on a property, it does not mean that the person who has the encumbrance is the new owner, but it means that the person has restricted how the actual owner of the property uses his or her own property. So in mortgages, other than the fact that there must be a contract, there must also be an encumbrance on the immovable property. Another characteristic of a mortgage is that the property must in itself be an immovable property. It must be either a land or a building. It must be attached to the soil. So you cannot mortgage a book. You can only mortgage houses or lands or buildings of any sort or kind. And the property should also be alienable, which means that it must be capable of being transferred from one person to another. So these are the characteristics of mortgages that I do hope you remember. Under NRCD 96, a mortgage must be registered, and that has also been emphasized in the Land Act 2020 Act 1036. So when you create a mortgage, you must ensure and you are obliged to ensure that it is registered. This obligation is on the mortgagor and not the mortgagee. So if the mortgagee in this case is a bank, it is not the bank that is required to register the mortgage. It is you, the individual, who went for the loan from the bank. You must ensure that you register it, and you must also include the property that has been mortgaged to emphasize that even though it is your property, an encumbrance has been placed on it, and thus you are restricted from dealing with the property as you ordinarily would have had you not gone for that loan facility. Whenever the mortgagor defaults on his obligations under the mortgage contract, there are a number of remedies that are available to the mortgagee, and the mortgagee can enforce any of them. One of these remedies is that the mortgagee has a right to sue the mortgagor on his personal covenant. I stated that a mortgage is a contract which is evidence in writing, and contracts have terms and conditions attached to it. When it comes to landed property, these terms and conditions are known or classified as covenants, which I made mention of in my video on leases when I was speaking about covenants. So mortgages have covenants attached to it. And if the mortgagor fails to fulfill his obligations under the contract, the mortgagee has a right to sue the mortgagor and ask the court to inform the mortgagor to fulfill his obligations under the agreement. Mortgages are characterized by loan facilities, so the obligations will be the repayment of the loan. So usually what the mortgagees do in these instances is that they can take you to court and ask the courts to order you to pay up the loan you have taken from them because you are failing or you have defaulted in the payment of the loan. Another remedy that is available to the mortgagor is the appointment of a receiver. A mortgagee can apply to the court for the court to appoint a receiver to deal with the immovable property. As I stated earlier, mortgages have immovable properties as one of the characteristics of these agreements. And if you default in the payment of the loan, the mortgagee has a right to apply to the court for the court to appoint a receiver. This person who has been appointed has the right and the power to take possession of the mortgage property, to collect by demand action in the name of the mortgagor or mortgagee, or otherwise the income including arrears from the mortgage property. So the property could have been rented out to someone, and this receiver will have the rights and the power to take the rent from the people who the property has been leased to, and the money taken will be given back to the mortgagee to help fulfill the obligations the mortgagor owes to the mortgagee under the mortgage. Another remedy would be the taking of possession of the mortgage property. Sometimes the mortgagees have the right to possess the mortgage property if you fail to fulfill your obligations under the agreement. Upon default of the mortgage, the mortgagee also has a right to sell the mortgage property when they take possession of it. That was emphasized in the case of Republic versus High Court Accra ex parte Chinto, which I encourage you to read that case because that case talks a lot about mortgage properties. However, one of the rights a mortgagor has in the property or the mortgage property is the right of redemption. A right that a mortgagor has to the mortgage property is a right of redemption. This right exists for mortgagors because the mortgagor always has a right to redeem the property before the property has gone through foreclosure. When we talk of foreclosure, it occurs when the mortgage property has been sold in satisfaction of the debt that the mortgagor owes to the mortgagee. That is seen in section 18, subsection 10 of NRCD 96. It's also under the Land Act, so I encourage you to read the provision to understand it. If the mortgagor has been able to fulfill his obligations under the mortgage, he has the right to redeem the property that has been taken from him by the mortgagee. But he can only do so before the property has been sold to a third party. Therefore, in a mortgage contract, if there is any provision that prevents the mortgagor from redeeming his property, that contract and that provision in itself will be void, because the right of redemption is a necessary right that a mortgagor has in relation to a mortgage property. This brings us to an end to our discussion on mortgages. I spoke about what a mortgage is. I explained who mortgagors and mortgagees are. I gave the characteristics of mortgages, and I also spoke about the rights mortgagees have to a mortgage property. I ended with the right of redemption a mortgagor has to a mortgage property. Thank you for joining us on this wonderful session. Kindly do not forget to like, comment, subscribe, and share our videos to your friends and peers for them to learn about mortgages.